Let's continue, class. This is our second lesson, or I labeled it as lesson 2.2 para hindi masyadong mahaba ang pakikinig nyo ng lecture. First, let us define quasi-legislative power. So this is the exercise of delegated legislative power involving no discretion as to what the law shall be, but merely the authority to fix the details in the execution or enforcement of a policy set out in the law itself. So what are the keywords when we talk about the definition of quasi-legislative power? First, it must have a delegated authority. There must be no discretion as to the law itself. It must have an authority to fix details, and it must be concerned with the execution or enforcement of the policy. So when we talk about quasi-legislative power, it must have the power to create rules and regulations which must be delegated by the legislature to administrative agencies through an enabling legislation. This delegation of authority allows agencies to fill in the details and implement the broader policy set forth by the legislature. Another thing is that quasi-legislative power has no discretion as to what the law shall be, meaning they do not have the authority to create new laws or deviate from the legislative intent. Instead, they are tasked with interpreting and implementing the law through specific rules and regulations only. While agencies class have the discretion to determine the specific details and procedures necessary for implementing the law, they must do so within the parameters established by the legislature. This includes specifying standards, procedures, and requirements to ensure compliance with the law and within their sphere of authority. The quasi-legislative power is primarily concerned with the execution or enforcement of policies set out in the law. Remember, class, that administrative agencies use their rule-making authority to operationalize the legislative intent and ensure that the law is effectively implemented in practice. What then are the kinds of quasi-legislative power? We have legislative regulation, we have supplementary or detailed legislation, we have contingent legislation, and interpretative legislation. Let us discuss this stuff one by one. When we talk about legislative regulation, it involves the promulgation of rules and regulations by administrative agencies under the authority delegated to them by the legislature. These regulations have the force of law and are designed, class, to implement and enforce the statutes enacted by the legislature. Administrative agencies, remember this, create legislative regulations to address specific issues or situation within their area of expertise only. So for example, the Department of Health in the Philippines may issue regulations governing the licensing and operation of healthcare facilities, ensuring compliance with health standards and regulations. Next is the supplementary or detailed legislation. This refers, class, to rules and regulations created by administrative agencies to provide guidance and clarifications on existing laws. These regulations aim to fill in the details of the law and make explicit what may be general or ambiguous in the statute passed by the legislature. So for instance, the rules and regulations implementing the labor code in the Philippines provide specific guidelines, class, on labor standards such as wages, working hours, and employment conditions to ensure uniform application and enforcement of the law. Next, we have contingent legislation. What does this mean? Contingent legislation, class, grants administrative agencies the authority to address specific situations or contingencies as they arise. Under this power, administrative agencies can determine whether particular conditions or events have occurred warrant the enforcement or suspension of a law. So this allows agencies to respond flexibly to changing circumstances without the need for legislative intervention. So for example, during a public health emergency, yung ating pong Department of Health, gaya nung pandemic, nung nag-COVID tayo, the DOH enacted regulations, imposing quarantine measures or restrict public gatherings to contain the spread of the disease. Dahil po at that time, nagka-pandemic tayo, and that concerns the Department of Health. Therefore, the Department of Health can do contingent legislation. Ano nga ang contingent legislation? Meaning, they can create rules and regulations when there are different contingencies. Lastly, we have interpretative legislation. Interpretative legislation class involves the issuance of rules and regulation by administrative agencies to interpret and clarify the provisions of a statutes released to the public. So these regulations provide guidance on the proper interpretation and application of the law and are binding on all concerned parties until changed or revoked itself. So interpretative regulations help ensure consistency and uniformity in the application of laws and regulations. For example, ang ating Bureau of Internal Revenue issues circulars to provide interpretations and guidance on tax laws and regulations, helping taxpayers understand their rights and obligations under the law. So ano po ba ang kailangan to have a valid exercise of our quasi-legislative power? First is that it must be promulgated in accordance with the prescribed procedure. Second, the exercise must be reasonable. Third, it must be issued under the authority of law. Fourth, administrative regulations issued for the purpose of implementing existing law pursuant to a valid delegation are included in the term laws under Article 2 of the Civil Code and must therefore be published in order to be effective. Remember the 15-day rule. It must be within the scope and purview of the law. And lastly, it must be filed in the ONAR or the Office of the National Administrative Register of the University of the Philippines Law Center. Explain natin isa-isa. The first requisite to have a valid exercise of a quasi-legislative power is that it must be promulgated in accordance with the prescribed procedure. Ano po bang procedure? This requisite emphasizes the importance of following the proper process and procedures established by law or regulation when promulgating quasi-legislative measures. Meaning, it must follow a standardized method for creating and implementing regulations which promotes transparency and accountability in the regulatory process. So, kailangan pong pag-usapan muna and must follow the proper procedure on how to pass rules and regulations in a certain government agency. Second is that it must be reasonable. This requirement class necessitates that quasi-legislative measures are rational, fair, and not arbitrary or capricious. Regulations must be based on sound logic, evidence, and consideration of relevant factors to achieve their intended purpose. You must always remember, class, that reasonable regulations strike a balance between achieving regulatory objectives and respecting individual rights and interests. What does it mean when we say issued under authority of the law? The quasi-legislative measures class must be authorized by law or statute, granting administrative agencies the legal authority to create regulations. If you are not given the power or that quasi-legislative power, then we cannot ensure that the regulations are grounded in a statutory authority. If you do not have quasi-legislative power and you promulgated a certain rule or rules and regulations, then it is not ultra vires. It is now beyond the power of the agency, meaning it is void. What does number 4 mean? This means that the legal status of administrative regulations as a form of law, subject to the same requirements and principles applicable to the statutes, must be followed. Regulations class must be published to inform the public of their existence and to give them legal effect. Ilang days nga yun? 15 days. Or unless it is stated there that it must take effect immediately. This ensures that individuals affected by the regulation are aware of their rights and obligations under the law. Next is that it must be within the scope and purview of the law, meaning it must align with the objectives, principles, and provisions of the enabling statute or law that grants authority to the administrative agency. Regulations class should not exceed boundaries set by the enabling law, but rather be consistent with its purpose and intent. This ensures that regulations are not arbitrary, but are closely tied to the underlying legal framework. Lastly, it must be filed in the ONAR or the Office of the National Administrative Register of the University of the Philippines Law Center. This requirement class involves the formal filing in the ONAR. Filing ensures that regulations are properly recorded, cataloged, and accessible to the public. This act enhances transparency and facilitates legal research and compliance with regulatory requirements. What are the guidelines to rule making? Always remember this because this will be asked in your constitutional law. First is that it must be consistent with the law and the Constitution. It must have reasonable relationship to the purpose of the law. It must be within the limits of the power granted to administrative agencies. It may not amend alter, modify, supplant, enlarge, limit, or nullify the terms of law. It must be uniform in operation, reasonable and not unfair or discriminatory, and must be promulgated in accordance with the prescribed procedure. Let us go to the first one. It must be consistent with the law and the Constitution. This guideline class emphasizes that rules and regulations must not contradict or violate existing laws or constitutional provision, because always remember, the Constitution is the supreme law of the land, and if you violate the Constitution, your rules and regulation is automatically void. Regulations should align with the principles and objectives laid out in the enabling legislation and must not exceed legal authority granted to administrative agencies. Remember that our rules and regulations, or the rules and regulations issued by our administrative agency, must be under the authority of law. Otherwise, it is not ultra vires, or it is beyond the power of the agency. When you do this class, you ensure consistency with the law, and the Constitution upholds the rule of law and prevents regulatory overreach. Second, it must have reasonable relationship to the purpose of the law. Regulations should be directly related to and in furtherance of the objective and purposes of the enabling statute or law, meaning they must be designed to achieve the intended goals of the law effectively and efficiently. Regulations class that lack a reasonable connection to the underlying purpose of the law may be considered arbitrary or beyond the scope of the agency's authority. Third, it must be within the limits of the power granted to administrative agencies. Administrative agencies class derive their rule-making authority from enabling statute or laws passed by the legislature, meaning it can be from the Constitution or from an existing law. Regulations must stay within the boundaries of the powers delegated to the agency by the legislature, because class, an agency cannot exceed their statutory authority or engage in rule-making activities unrelated to their designated functions. Because sabi ko nga, di ba, our administrative agencies must act only within the sphere of their authority. Third, when you have a rule-making power, you may not amend, alter, modify, supplant, enlarge, limit, or nullify the terms of law. This guideline class emphasizes that administrative regulations cannot change or undermine the provisions of the enabling statute or law. It must be noted that regulations must not contradict or override the express terms and requirements of the law, but should serve to implement and enforce them effectively. Regulations that attempt to amend or modify statutory provisions are typically considered what? Ultra vires, or beyond the powers of the agency. Fifth, it must be uniform in operation, reasonable and not unfair or discriminatory, meaning regulations should apply uniformly to all individuals or entities within the regulated scope and should not unfairly discriminate against any particular group. They must be reasonable in their application and should not impose unnecessary burdens or hardships, because regulations that are arbitrary, discriminatory, or impose unequal treatment may be subject to a legal challenge. Lastly, it must be promulgated in accordance with the prescribed procedure, meaning an administrative regulation must follow the proper procedure established by law or regulation. So ano ba ang scope nito? It must provide notice to the public. It must allow for public comment or consultation where required. You must obtain necessary approvals or authorizations. And remember that when you adhere to the prescribed procedures, you then promote transparency, public participation, and accountability in the rule-making process.